All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning and welcome to the North Carolina Court of Appeals. We have two cases for argument this morning. One will be in person here in the courtroom. The second will be a remote argument. So we confirmed the parties are ready to proceed in our first case. That's number 21-357 in the matter of the Mecklenburg County Board of Equalization and Review of Pop Capital Towers, LP et al. If the parties are ready to proceed, we'll hear from the appellant.
May it please the court, Lindsay Walker Hillis here on behalf of the Hillis firm, on behalf of taxpayers, Pop Capital Towers, P&L Coliseum Residential Developer LLC, P&L Coliseum LP. I represent each of those taxpayers. The facts are very similar. I will point out the differences in the three separate appeals as I go along. I would like to reserve 5 minutes of my time for rebuttal. Principally, there are three issues here today. One, did the Board of Equalization and Review comply with North Carolina General Statute 105-290, whether the affidavit submitted by Mecklenburg County, by Brooke Millard, is full of hearsay or if it actually contains admissible evidence. And three, I would say an issue of first impression, whether or not these tolling orders issued by the Supreme Court affected any timelines that would be applicable in this case.
One argument I saw in the trial record that I wasn't sure if you were pursuing now is the argument that there was no evidence of when the notice was actually received. So there seemed to be some discussion in the transcript hearing below about whether offices was open, when mail was coming in, whether they had a practice of finding some way to if mail came in over multiple days and the office was closed. But then I didn't see that in your briefing, so I was wondering what the status of that was.
Well, what I wish is before that hearing we had time to kind of fully develop that issue. Given that there wasn't a whole lot of evidence either way in the record, I felt like we couldn't really address it, unfortunately. But the evidence, in that hearing was that the office was not open. The clerk did come back and try to say, generally our policy is to stamp mail the first day we were closed, but we never really could get enough clarification where I felt comfortable really pushing that argument here. I wish we'd had more time to develop that below.
Thank you.
Okay, so the first issue is, did the Board of Equalization and Review comply with Section 105-290? And what there will be a lot of discussion, both from myself and my opposing counsel, is that this statute must be strictly construed. We agree. The appeal of Bass Income Fund, which is 115 North Carolina Appeal 703, it's a 1994 case. It says, yes, this statute must be strictly construed. But what opposing counsel wants is for it to only be strictly construed against my client, but not also strictly construed against his. It goes both ways. Now, what the Bass Income Fund case says, citing Pill versus Finch, it is our duty to apply legislation as written, whatever our opinion may be to the efficacy and the hardship it may impose on any individual case. So what does the statute say? It says that the 30 days starts to run the date the board mailed the decision. Now, the date mailed by the board. Now, if they wanted it just to be the date that it's mailed, the state legislature knows how to do that. They could have said the date the taxpayer was notified, the date the decision was mailed, but instead they used the very specific language, the date mailed by the board. Now, in Amani versus North Carolina Department of Human Resources, it's 114 North Carolina Appeals 668, a 1994 case, citing State versus White. The legislature is presumed to have intended a purpose for each sentence and each word in a particular statute, and a statute is not to be construed in a way that makes any portion of it ineffective or redundant. So mailed by the board means something. If the legislature wanted something else, they could have said that. Moreover, tax statutes in this state are to be strictly construed against the state and in favor of the taxpayer. Walmart Stores East versus Hinton, which is a 197 North Carolina Appeals 30, Penn site 42, a 2009 case. Moreover, if this court determines that the statute has two constructions, then any uncertainty must be resolved in favor of my client, and that is Lennox Inc. versus Tolson, 353 North Carolina 659.
So one argument I think we're going to hear for your friend from Appali is that the board is the one that provided this notice. So you can think of it similar to in a civil action where it's the complaining party, the party that's initiating a lawsuit that has the obligation to provide service on the other side, but oftentimes it will be, let's say, the sheriff that physically delivers a copy of the complaint, the summons. But the idea is those other parties are working on behalf of the party who has that obligation. So I think your friend for the Appalachian can say that's all that's going on here is this essentially, we've contracted out to an agent and we're the principal. So it's being done by someone else before us. So what's your argument of why that doesn't work?
Thank you. It's exactly where I was headed next. So in this instance, the Board of Equalization and Review is a third party, right? They're supposed to be a neutral party that hears these taxpayers' appeals. They take an oath to uphold their duty without political or friendships, those kind of things. Only the board takes the oath. The clerk, which is the assessor, isn't technically a member of the board. He's the clerk that maintains the minutes. And in this case, what that affidavit says is we have a contract with the assessor, not that neutral board. So the board didn't contract with them. The board didn't oversee it. You know, the statutes allow the Board of Equalization and Review to have committees or appointments or have other people do that, so long they oversee it so that their oath is maintained. That's not what happened here. It is the Board of Equalization and Review had no contractual relationship whatsoever with South Data.
So who, in your opinion, would have to do the actual mailing to comply with the statute?
I think that the Board of Equalization and Review should be the one doing the mailing, like in most counties across the state. Now, if they want to go through their appointment that complies with the statute to have a committee or have a third party, then they need to be the one that controls that contract and controls that outcome. But that's not what's happening here. This is a separate, the person that we said didn't do the assessment correctly, the other party is the one serving it when it should be, for lack of a better term, the court, that neutral third party. In this case, the statute doesn't allow for that. The legislature could, but they have not set forth doing that. And these statutes, if you look at 290 and 105-290 and 105-296, they specifically outline which duty goes to which, to the assessor versus the Board of Equalization and Review. And what the appellee wants to do is conflate those two and say, oh, they're one and the same. But no, the taxpayer is supposed to have this neutral third party. And so the second point is this affidavit that they have put into these records. And before I get into this affidavit, I want to briefly highlight one difference between these three appeals. The two P&Ls, there was a supplemental affidavit put in from Milner to show from the county's position that the BOER decision was mailed to the taxpayer and also mailed to the agent as requested by the taxpayer. In Pop Capital Towers, they never mailed it to where the taxpayer asked them to mail it to the agent. They never mailed it. There's no evidence whatsoever. They put no affidavit in saying that it was mailed. And then they say, oh, well, it's harmless error because they eventually got it. Well, when we're talking 1 or 2 days or 3 days, not getting that decision by the agent is a problem. That causes harm to the taxpayer. Now, back to these affidavits. We contend that there is a hearsay problem, and of course, there are hearsay exceptions, such as the business record exception. And so what Ms. Millard says is, I personally reviewed the print file, submitted and attached, that was submitted and attached the notice of decision. Notably, she doesn't go through any of the foundational requirements to get business records in. She doesn't say that this screenshot that she attaches was prepared at or near the time that the acts were reported. She doesn't say that it was prepared by or from information transmitted by a person with personal knowledge. She doesn't say that these screenshots are kept in the ordinary course of business, or that it's a regular policy of South Data. There are no foundational requirements to allow this screenshot to be a business record. She would had to have said those things in her affidavit for them to even have a starting date. And if there's no starting date to prove that these things were indeed mailed by March 2nd, then our appeals were timely. Next.
When dealing with this jurisdictional prerequisite, the question of whether or not the appeal is timely, at this stage, is there case law that says that you have to apply the rules of evidence to the jurisdictional facts that are being assessed there?
Well, it says that you have to prove that the data was mailed. So if it has to be proved, then I would suggest that the rules of evidence have to apply, because the rules of evidence apply to the PTC. So if they apply to the PTC, then they would have to apply to any questions submitted there.
Right. I was just curious if in this, because it's sort of a preliminary question where you're examining these, you're having to make some determinations about some jurisdictional facts to figure out, do we even have the power to adjudicate anything in this case? I just didn't see a case that had used the full kind of panoply of the rules of evidence then, but it may just be because this case is somewhat novel and that it's never happened before.
I think that's the case. I didn't see anything, but also didn't specifically research that issue.
I want to ask a question about the lack of postmark on the envelopes. And obviously, GenStat 105-290E says there has to be a postmark, right? And your argument is that you have an affidavit because you didn't know whether there could be a postmark. Is that correct?
Right. And so from what we understand is that my office took it. We know exactly what time she put it in the hands of the Postal Service. And so generally the policy is for them to run it through the machine and there to be a postmark. I know that just from reviewing them, a lot of times the postmark it'll just be the little scan line. It'll be through the back if there's already a metered postmark on it. And unfortunately, she should have just postmarked it entirely there. But our office had been closed because of COVID. She went to the post office. She got the timestamp on other things that she mailed certified mail. She got mixed up. She handed it to them. And so my question has always been, was there a postmark anywhere on that envelope? But the PTC scans that first page, and we've never been able to get a full copy of the original envelope because they don't maintain that. So, you know, to be perfectly honest, I have no idea whether there is a postmark on that envelope on the back of it because they don't keep it.
Okay, and I just want to make sure in the brief it says that taxpayers were without the ability to confirm that no postmark.
Right.
But just to be clear, when you go to the post office knowing you need a postmark, you hand it to the mail carrier and say,
Right.
postmark this and let me see it, correct?
She should. I wish my staff would have done that, but she went to the post office. She handed it. Everything else got delivered. So.
But I just want to make sure that it's not that they weren't without the ability to know whether it was postmarked, because you hand it to the mail person and say, I want to see you hand cancel this, correct?
Right. She did
Okay.
not. She did not see whether there was a hand cancel.
Okay.
Now, the last issue that I would like to talk about is this tolling, right? All of our lives change.
Before you get to that, can I go back to, so you can have a scenario in the law where one principal has an agent, and then that agent is also a principal that has another agent acting for them. And then it would sort of flow up the chain. So by the one agent acting is an act of the principal, then that next agent that's also the principal in the middle, their actions are and so my question to you is, in this record, is there a link that shows that the board authorized or instructed the assessor to provide the notice, and then the assessor hired the third-party contractor, South Data, I believe is the name, to do that for the assessor? Is that link in the record?
It is not. There's no link. The only thing that they have pointed to are the statutes, and the statutes outline the specific duties of the clerk and the specific duties of the board, and nowhere in there does it say that is a duty of the clerk. It's specifically in the other statute, and the appellee has put forth no contract saying that, or appointment or a committee that the BOER did to make that happen. So nothing like that has been put in.
And what is just in general the relationship between the assessor and the board itself?
So the statute does say that the clerk, that I guess it's the chief assessor, for lack of a better term, is the clerk to the board. But the statute 322 goes forth and says that the clerk, it defines the clerk's role. shall serve as the clerk of the Board of Equalization, shall be present in all meetings, shall maintain accurate minutes of the actions, and shall give the board such information as he may have or can obtain to respect to the listing and valuation of the taxable property. But then if you go on down to the powers of the board as opposed to the clerk, that's where it says give written notice to the taxpayer. So I guess it is possible that under this ability for the BOER to appoint committees, that they could have done some official appointment to say, hey, clerk, you're in charge of hiring someone to do our duty, but there's no evidence of that in the record.
So I guess my question is, like, does that have to be in the record, or whose burden would it be to get the answer to this question of is the authority, if it's not expressed in the statute, and the argument is, well, but it's sort of within the inherent powers of the board to instruct an assessor, we want you to do this and we want you to contract out to someone, and we don't have any evidence of where that comes from or what the practice has been. I mean, whose burden is that? You're the appellant here, so typically we put the burden on you to put things in the record, but what?
Understood. But I would submit that the statute controls unless there's something in the record to show otherwise. And what the record shows is just that we follow the statute. And if they had followed the statute, the Board of Equalization and Review would have been the one to take this action as required by 105-322G1F. And they didn't do that. Oh, excuse me, it's actually 105-322G2D. The 1F is just to give general written notice on other issues. Now, this other issue that I could only find one unreported decision by the Court of Appeals, or unpublished rather, dealing with this COVID-19 and these tolling orders. And so, all of our lives changed in March of 2020. And in every state, and especially in North Carolina, there were a myriad of orders that came down. And they were, initially it said on March 19th, the Supreme Court of North Carolina said, all pleadings, motions, notices, and other documents and papers that were due to be filed in any county of the state on or after March 16th and before the close of business of April 17th shall be deemed timely filed. And then these orders they keep coming, right? And then they say, oh, well, they don't apply to the appellate courts. And then the Supreme Court comes back and says, those deadlines are extended too. And then later, because the North Carolina Supreme Court didn't want any ambiguity as to what this applied to, so that everyone could have some comfort, on May 30th, so well after all of this, on May 30th, they came out and said, in any matter, it does not have any limiting language like some of the others. In any matter in which a deadline to file a notice of appeal fell between March 13th and June 1st, the deadline for filing such appeal is hereby extended. That resolved all ambiguity in any matter. Now, what appellee wants...
Yeah, I think one argument here for friend for the appellee is, so just let me ask the question in the abstract, but do you think that our state Supreme Court has the power, just, the justices wake up one day and say, we just want to change the filing deadlines, for the board review here, so we're going to do it. We'll enter an order and say, we're moving it to 60 days or something like that. I mean, do you think that the Supreme Court, on its own initiative, has the power to enter an order that would do something like that?
Just one day they wake up, no. But with the orders from the governor of North Carolina declaring the pandemic, and with those kind of catastrophe, I guess for lack of a better word, those rules changed. When there is an emergency such as a pandemic, the rules of general engagement change, so they were allowed to go out and extend deadlines. And what the appellee is suggesting is that the PTC is on an island, and that every other appeal was told, every other deadline in this state except for the PTC was told. So if we had already been in the PTC and we were filing a notice of appeal to this court, we would have been told.
Right, and I think that is precisely the argument we're going to hear for your friend for the appellee, is that the critical distinction is because that second appeal, seeking judicial review, you're now in the court system.
Right.
But until you get to the court system, the courts, no matter how much they might want to help during the pandemic, just can't change the rules for people outside the court system. That's for other branches of government. And there's just no evidence that any administrative agency with any authority to do that changed the deadlines here. So, I mean, what's your response to that?
Well, so, I would say that based on some of the initial orders, that his argument's a lot stronger. That the argument, in those initial ones, it talks about in a civil action, in a special proceeding, in a criminal action, and had all that limiting language. And then the North Carolina Supreme Court came back and said, hey, I don't want any ambiguity in all matters. In all matters, that's exactly what it means, in all matters. And then you've got this over here on the Office of Administrative Hearing. They entered similar orders. I mean, otherwise, you've got this one little bitty pocket of taxpayers that was the only thing that wasn't extended in a time where I was under a stay-at-home order. All of you were under a stay-at-home order. Everyone's under a stay-at-home order. And so that's why these deadlines were told, so that we wouldn't all be out. It was trying to minimize the spread. And so it wanted everyone to stay at home and to not have these deadlines hanging over their head. And so that's what I believe the North Carolina Supreme Court was doing when it said in all matters. I mean, if they don't have the power to do that, then I don't see how, any, at least what the appellee is suggesting is that no one has power over the PTC. And that just doesn't seem to match with any of the other stuff that was going on. And so the only decision that we could find was that unpublished one that we cited in our brief. Let's see.
Is the Office of Administrative Hearings part of the executive branch?
Yes.
Okay, so if the Supreme Court says all matters, doesn't it only have the authority to designate all matters within the judicial branch?
I'm sorry, can you repeat your question?
Yeah, so if the Office of Administrative Hearings isn't subsumed in the judicial branch, and the Supreme Court designates all matters that apply to its orders, wouldn't it be talking about all matters in the judicial branch, because it doesn't really have the authority over the administrative branch?
So, the timeline of all of this happened, I would say that May 30th order was trying to clarify, whoops, I'm sorry about that, that was indeed all matters. And so that there was no ambiguity about the initial orders and this Office of Administrative Hearing, that it kind of took all the ambiguity and said that everything was extended. And so what the appellee says is that even with the Office of Administrative Hearings, we're not under that either, that the PTC really is an island on its own, and I feel like someone has to have jurisdiction over it. And if the administrative hearings were all told for all contested proceedings, for everything else, and all matters in the Supreme Court, that we have to be covered from somewhere. The PTC cannot be this island up on its own. Someone has to have authority over it, and everything was told in both places. Thank you.
All right, thank you, counsel. We'll hear from the appellee.
May it please the court, I'm Ron Gibson. I represent Mecklenburg County in these appeals from the Property Tax Commission. The court should affirm the Property Tax Commission. They properly applied the appropriate statute. The COVID orders did not apply to the Property Tax Commission, nor the 8 other administrative agencies listed in 7A 29, I believe. That is, all the statute granting the courts the authority to hear appeals from those agencies. There are 9 in there. The Administrative Office of the Courts is the only one that entered any kind of order relating to COVID that I'm aware of, and they had an enabling statute from the legislature authorizing them to do it. The Supreme Court, or the court system, had an enabling statute that the Supreme Court acted pursuant to. It's 7A 39B1. So the Property Tax Commission's not sitting like some island. The Property Tax Commission, like all other administrative agencies, had no authority to change these jurisdictional deadlines. So there were no orders entered. except in the administrative office of the courts where the legislature gave them the authority and the chief judge of the court entered such an order. So the Supreme Court only has jurisdiction over administrative agencies where it's granted by the legislature. And in this instance, there was no authority to do what might have been a good idea, but the agencies didn't do it. So that issue ought to be very clear that the Supreme Court's orders did not extend the jurisdictional requirements before any of the administrative agencies. What we have is a party seeking to find things wrong with the appeal process, but the facts are, and this is just like the Bass case from the early to mid-90s, an administrative person in the office of the taxpayer or the lawyer took these things to the post office and did not do what the statute clearly requires. The notices have it in two places. You must either deliver this to the Property Tax Commission or you must have a postmark from the U.S. Postal Service. We might say that is a terrible requirement, but it is the requirement the legislature has put in place, and the Court of Appeals has said that is what will be applied as long as it is in the statute. So in this instance, as Ms. Hillis acknowledged, her assistant took the items to the post office. Well, in Bass, the person did a step more. They prepared it to be served or sent by certified mail. It got there on day 31. Now, this court has dealt with statutes of limitations. Sometimes it's harsh results, but those are the results, and that's what's there.
Well, your friend also argues, sort of what's good for the goose type argument here, saying, look, the statute also quite clearly says it's the board that will provide the notice. And there's an affidavit from a private company saying, I do this work on behalf of the Mecklenburg tax assessor's office, with whom I have a contract.
Sure.
And the argument I understood from your friend is the link is not there to the board, to any proof that this is the board carrying out their statutory duties. So what's your response to that argument?
Well, first off, where is there a requirement that there be some link, some clear statutory link? What you have is citizen volunteers appointed by boards of commission around the state to serve on the BER. In a large county like Mecklenburg, where they're mailing thousands of pieces of mail for each session, the assessor, by statute, serves as the clerk for the board. The legislature has given the assessor broad authority to do all things reasonable to carry out their duties. And that statute is cited in our brief. And in this instance, the assessor has done a reasonable thing. He's contracted with a mailing service to mail these thousands. I think one of the affidavits says there was a 4,000-piece mailing at that point. So this requirement of a link, if you will, it's not in the statute. But what you do have in the statutory framework is the assessor being appointed the clerk for the board, the assessor having the authority to take reasonable steps, including, there's a phrase in there, including hiring experts and appraisers and doing all other reasonable things necessary to carry out the work. So in this instance, I don't think there's some requirement that's not being met. The county assessor, especially in a large county like Mecklenburg, and I suspect the other large counties in the state do the very same thing. But these volunteer members aren't licking envelopes and putting them in the mail. Some employees of the assessor's office or the county employees or an outside mailing service is doing this.
So suppose some other employees of Mecklenburg County, suppose the board was not ensuring that these taxpayers were receiving the notice, and some other just employees in Mecklenburg County said, oh geez, we need to make sure that everybody gets their notice or we could have problems. So they just go out and they start mailing out the notices. It's not somebody that has any connection to the board's members. But people are getting notice. I mean, would your position be that that's good enough as long, or do you at least acknowledge that the board has to have some role by statute in assuring that it happens?
Well, I think the board does have a role in the scenario that I'm talking about, and that is that its clerk, authorized by statute, is carrying out that function. So it's not some random set of employees. The assessor, a pretty significant position in the county, acts as the clerk, and the assessor is hiring these contracting with these folks to get it done. To me, that's a logical connection.
Right, but I think what your friend, the argument I understand your friend making is, you know, if we're going to apply harsh rules here, let's be harsh or let's be strict about all the provisions of the statute. And I think the argument is, if we're going to be strict about it, the tax assessor can certainly enter into that contract if it's doing so as the clerk for the board. But the evidence that is in the record is South Data said, no, I have a contract with the tax assessor, you know, to carry this out. So I think that's the link that's being argued. That's missing is some evidence that the board instructed the tax assessor, as your role as the clerk for us, we want you to go out on our behalf and contract with some private party to do this.
I think that would be strictness, if you will, an unnecessary level of strictness given the situation. I interpret the argument to be, well, the legislature hadn't said you can do X, and you can do Y, and you can do Z. So since each of those things is not in the statutory framework, it's improper for the county to do it that way. And to me, frankly, that's a nonsensical interpretation of a statutory framework to get this done. Because the legislature didn't see fit to say, oh, you should have each step there. The legislature gave the assessor broad power to get the job done. And that job looks different in a Wake County or Mecklenburg County as compared to some of the very small counties out east where you might have only a handful of these appeals, where in Mecklenburg you have thousands during each cycle. But let's not forget, and I remind you of the Louisiana Pacific case. Mecklenburg pointed out that the decisions were mailed. They got the decisions. They signed a notice of appeal within the 30-day period. So there isn't any question of, oh, you're not doing it properly. We didn't get the notices, so we've been harmed. Court, please throw out this entire process. They had the notices of decision in hand, so the lack of diligence of following the requirements, they were not followed by the taxpayers. They took them to the post office. They didn't take the step of getting the document postmarked as required. And the commission's 3 orders says there was no postmark on the envelope.
But aren't we still talking about jurisdiction, and if those notices weren't mailed properly, then they still haven't received proper notice, so that 30 days still hasn't run?
I would disagree with Your Honor. We have shown through that affidavit that they were mailed. And unless the appellates can cite to some statute that's been violated, that is, we clearly didn't do it properly.
Well, the argument is that this statute has been violated, right? 104, 105, 290. So that's the argument. If it actually had to be the board and not the tax assessor.
That's the argument, and I'm saying to the court, that's a nonsensical
I disagree with it. I get
argument.
that, but I just want to make sure that we're talking about sort of the same thing.
But in Louisiana Pacific, the facts don't quite fit here. The argument was, we never got it. And the court said, doesn't matter. There was an affidavit that it was mailed, and you didn't file your notice of appeal within that 30 days. Yes, it's harsh, but that's what the courts have approved. I remind you factually, they had each notice in hand. They attached each BER decision to their notice of appeal. They didn't comply with 105-290 in terms of getting it postmarked or getting it delivered. And the law has been very clear that that's required. And the argument that the assessor didn't have the authority to go contract with someone to do the mailing shouldn't be sufficient to throw out the decision or to reverse the decision of the Property Tax Commission, where it's clear that they had the decisions in hand. They didn't comply with the statute, but they want to attack the process as a way to excuse their not filing it properly. So again, I'd be happy to respond to additional questions, but I would urge the court to affirm the Property Tax Commission. They applied the law both in the statute and as it has been interpreted by the appellate courts, and the commission's orders should be affirmed.
All right, thank you, counsel. Any rebuttal?
Just a couple of quick points. One, both in the Bass case and that Louisiana Pacific case, there's no question. In both of those cases, the board mailed it. So those issues were not raised that are raised here. So again, what Appley tries to do is conflate the duty of the tax assessor with the duty of the BOER. Now, the statutes 322, or 105-322 and 105-296 define the very defined and specific roles between the Board of Equalization and Review and the assessors. And, you know, if the statute wanted to say the clerk as the assessor, but it doesn't. It says the board, it doesn't say the clerk. Those roles are very defined. And so I would say that they have not met the technical requirements of 105-290 when it says that the board should, the board mailed the decision. The board never mailed the decision. And another thing that wasn't addressed in Appley's argument is this hearsay issue. This affidavit, we do not believe, puts forth any admissible evidence to say the date that BOE decision, or BOER decision rather, was mailed. So those things have not been met. And it does matter. Appley keeps saying, well, you got the decision. Yes, but when did we get the decision? Because we only had a few days to get it to the post office, and had it been brought to the post office earlier, these couple days wouldn't matter of whether it had been hand canceled or not. But so there are issues with that affidavit. There are issues that the contract with the assessors, not anyone on the board, did this. So we submit that this motion to dismiss should be reversed, and we should go back to the Property Tax Commission, or even go back further and have the board actually reissue the decision and start our 30 days all over again. Thank you very much for your time this morning.
All right, thank you, counsel. We appreciate your arguments, and we will adjourn. Mr. Clerk?
All rise. This session of the North Carolina Court of Appeals is adjourned.